Hello there and welcome once again to The Verdict. Mick Cornett with Kent Myers. We're here every week meeting interesting people and dealing with topical issues. And this week we're going to revisit amateurism in sports and the possible effects it could have on intercollegiate athletics.
Yes, and we wanted to do that because that's a topic that is likely to hit the Supreme Court relatively soon. And it could dramatically change the scope of payment to athletes that has previously been not allowed and may be allowed in the future. We've asked back this week Ryan Ray to come visit with us about that. Ryan is an attorney in Tulsa who has significant experience and quite a bit of knowledge about this subject matter. Besides just being a good lawyer and a good trial lawyer, he knows a lot about this particular topic, and we're going to find out what he thinks about it.
Yeah, I mean, the topic's not new. Just over 100 years ago, Jim Thorpe was kind of center stage, the great Oklahoma athlete, about was he a professional athlete? Did he have to give back his Olympic medals? It's evolved in that 100 years, but it's basically the same issue. And we're gonna revisit it today and see what effect it could have in the future on college athletics as we know it. We'll be right back.
Been fortunate enough to premiere every film that I've produced at Sundance. Seeing your film on the big screen for the first time in front of an audience at the Sundance Film Festival is unmatched. I'm Chad Burris. I'm an attorney, a film producer, film financier, economic development financier, and I'm Chickasaw. Nobody can argue that modern day media, cinema, has perpetuated this myth, this idea of the Indian and what that is. And just the idea that, all Indians look one way or all Indians act one way is a terrible injustice. Being able to have filmmakers tell stories that are representative of some element of his surroundings, his upbringing, what they know, what they see through their own eyes, that other people get a chance to bear witness to around the world. I think that's amazing. For me personally, being an Indian today means being responsible, honest, progressive, and giving that back to the community.
Learn more about today's Chickasaws at profilesofanation.com.
Welcome back to the set of The Verdict. Mick Cornett and Kent Myers. Kent's going to introduce today's guest.
Yeah, as we spoke about in the opening segment, we're really pleased to welcome back to The Verdict Ryan Ray, an attorney with the Norman Wohlgemuth and Ray firm in Tulsa. That may not be the precise name, but that's close enough. Ryan is an Arkansas native. He did his undergraduate work and law work in Arkansas, the law work at the University of Arkansas, where he graduated summa cum laude. He has done trial work, both of a civil and criminal nature. He had a stint in the reserves for the U.S. Marine Corps. He is listed in all the right places and all the right, he's received all the right honors, such as super lawyers, National Academy of Criminal Defense Lawyers, and I could go on and on. This is his third appearance with us here on The Verdict. Ryan, welcome back.
I'm glad to be here. Thank you very much.
Ryan, as sports evolved throughout the 20th century, there was a day when you were cleanly defined as a professional or an amateur. And as the 20th century evolved, there was a blurring of the lines, and each sport seemed like it was taking it differently. And the Olympic athletes were being treated differently, and college athletes, were constantly, juggling that description and that line of no turning back. This seems like a brand new discussion because the courts are more heavily involved and they could be breaking down some long-standing ideals.
Absolutely, and I think one very recent and potentially very influential case is that brought by Ed O'Bannon against the NCAA. I'll, of course, always remember Ed O'Bannon playing and defeating my beloved Arkansas Razorbacks in the 1995 National Championship game. But in this case, he actually brought a challenge on behalf of himself and actually a class of really all current and former football and basketball athletes in NCAA schools, which obviously are the two largest money-making sports. And his challenge was principally based upon the use of his name, image, and likeness and that of others by the NCAA, both in footage, broadcasts, and even video games. And Mr. O'Bannon,
Without his permission.
without his express consent.
Yep.
And the challenge really focused on the NCAA's ability to use his name, image, and likeness with the limit that no compensation could be provided for that use except for the payments permitted under the NCAA scholarship regulations.
Right. And I guess that from a legal argument standpoint, no one is required to play college sports, but when you do, though, you accept kind of the culture of the day. I can remember there was a day when if you bought a collegiate jersey with a popular player's number on it, it didn't have their name on the back. And then at some point, it seemed okay to put the names on the back. And that seemed, obviously, at that point, you were selling memorabilia that was based on an amateur athlete's performances and reputation. And yet none of that money was going directly into players, directly or indirectly. And then with the video game culture today, I mean, it seems like there's a lot more money coming into the sport. So how do you get involved, and what's your take on all this?
So Mr. O'Bannon's challenge to these limitations on the amount of money that could be provided to athletes was brought under an act called the Sherman Act. It goes back to the late 1800s, and for the section he was proceeding under prevents combinations, conspiracies, or agreements to restrain trade. In other words, anytime a group of people or businesses get together to impose some other limitation that wouldn't ordinarily be there in a free market, the courts either outright prohibit that or look at it with a very scrutinizing eye. And so that Mr. O'Bannon and the other plaintiffs there were saying the NCAA is agreeing to fix the price at which my name, image, and likeness can be provided. And he said, in my opinion, that violates the Sherman Act.
Well, what about the argument that, now wait a minute, all the colleges and universities are the members, or most that play sports are the members of the NCAA. And if it gets done, that kind of decision, it gets done with the consent of the majority of the folks making up the NCAA membership, the colleges and universities. And if they didn't provide for it, why should it now be required?
And I think, Kent, that goes back to these antitrust principles, which is anytime a group of businesses or competitors has the ability to combine their forces and impose some limit, then that typically is going to be either prohibited or strictly scrutinized under the antitrust laws. There's a little bit of tension there when we're talking about sports leagues, and I think the courts have recognized that over time, which is a sports league or association like the NCAA or professional leagues. There has to be some agreements for the product to exist at all. In other words, if you can't get together and agree on some core principles, you really can't have the competition in the format that we know it in college basketball or football or really anything else.
Yeah, you have to know how many folks can be on the field or the court at the time. How will substitutions work? How long and wide will the court or field be? You got to agree on some things, or you won't have anything to compete with.
Right.
You can't do it. If you got to all be playing by the same rules, and to that extent, that's a combination. And some might say in restraint of trade, but the courts have, as you have said, have clearly stated in similar circumstances that that's okay because without that kind of collaboration, you won't have any product to market.
Well, does a collegiate athlete ever sign away their rights? Does the letter of intent that they sign coming out of high school, anywhere in that document, is there an opportunity for the university to say, look, they agreed to play under our terms and our rules, and they knew they weren't going to be compensated today or ever?
I think that's exactly the NCAA's position, but the antitrust laws still may apply, even in light of that. You still have, if you have a combination in what's called restraint of trade, that's typically illegal per se, meaning you just can't do it. But in the sports context, the courts have at least allowed sort of another analysis of the competitive versus anti-competitive effects, sort of some weighing. It's called the rule of reason. They've at least allowed that to come into play, and that's what the Ninth Circuit and even the district court in California in the O'Bannon case did.
What did they say? What did the court say?
So the lower court, the district court, I believe sitting in the San Francisco-Oakland area, she actually said that these are in restraint of trade. The Sherman Act applies. She went to this rule of reason and weighed the NCAA's interest in keeping athletes amateurs and allowing them to be part of the school community as opposed to just this subset of professional athletes, and said that while these are subject to the Sherman Act, they're going to be by and large okay, but she said that the NCAA should allow up to the full cost of attendance, not just the pure cost of paying tuition, but some other costs above that.
By cost of attendance, you mean, excuse me for interrupting, cost of attendance, you mean cost that the athlete must pay to attend that particular school.
That's right, and it would include not only tuition, it would include things like room and board, it would include books, it may even include some amounts for things like meals, and it's not a substantial amount of money over, but it's something more than merely what you walk into the registrar's office and pay for tuition.
Right. And on another note, at what point would the IRS say, well, that's a salary and it's taxable?
That's another good question, and it certainly is part of the equation. I think what was allowed even by the lower court was up to the full cost of attendance, and then the lower court actually allowed a $5,000 payment per athlete to be held in trust to access by them at some point in the future.
All right, Ryan Ray is our guest. We're discussing the NCAA, the O'Bannon case, and professionalism and how it deals with collegiate sports. We'll have more after this break.
Oklahoma's land and air, water and energy, they all matter.
Today, thanks to emerging technologies in oil and natural gas production, there are many new opportunities to conserve water.
Advanced methods help clean and recycle water from energy production. In fact, many producers are now reusing up to 50% of the water used in their well completions. Learn more about how Oklahoma producers are recycling water at oerb.com/bothmatter.
The good life comes naturally to Tulsa, where nature's beauty is matched with an eye for aesthetics. A legacy of neighborhoods graced with lawns and landscaping and handsome homes. A place that seems to have patented an ideal lifestyle. Bank First is loyal to the quality of life Tulsa assures its citizens, to the priority placed on education, culture, and growth. Loyal to builders who transform raw land into residential charm. Developers who see opportunity and add vitality to Tulsa's economy. Bank First serves both enterprise and private lives that need a loyal partner. It's how we help nurture this city's very good life. Bank First. Loyal to Oklahoma. Loyal to you.
Welcome back to the set of the verdict. Mick Cornett and Kent Myers and our guest Ryan Ray. We've been discussing amateurism, the O'Bannon case, and how the courts are now dealing with this conflict of rules and regulations and laws. And I'm wondering if I'm an average sports fan and I'm listening to this conversation, I might find it sort of interesting on the periphery, but how does that affect the individual fan? Are they still going to be buying tickets? Is there still going to be a top 20? Is there going to be some super league? And how does this affect Division II and Division III and NAIA? Do you have any opinions on how this shakes out?
Yeah, Mick, I think that the immediate effects of this may not be that noticeable to the average fan, but I think when you look at the Ninth Circuit's opinion, the Ninth Circuit Court of Appeals largely affirmed what the district court did, with pretty much the sole exception of these $5,000 payments, which they chose not to allow. But the biggest effect is the Ninth Circuit clearly said the Sherman Antitrust Act applies to the NCAA's amateurism regulations. And if that stands, and I think we can all fairly expect that the NCAA will petition the U.S. Supreme Court to take this case, and I think it's far more likely than not that the U.S. Supreme Court will take the case. So that'll probably be upcoming in the next year, those proceedings. But if that holding that the amateurism rules are subject to the Sherman Antitrust Act stands, I think we can expect a lot more incremental type of challenges to the amateurism rules under the Sherman Act, and there's going to be a lot more litigation. And if those rules are going to apply and the courts are going to apply them the same way or even close to the same way they do to private businesses, then I think in the future those rules may be challenged or struck down even in the long run.
Could we get to a point where high school athletes are going to the highest bidder or offering their services, and schools are bidding with cash or other types of compensation?
I think, Mick, under the rule of reason analysis that the Ninth Circuit applied, I think a pure open market auction is unlikely, at least any time.
But theoretically supportable.
Theoretically, it is supportable, but if you have the courts even paying some deference to allowing this type of structure, which wouldn't be allowable if it were a business, a manufacturing business that couldn't reach this type of agreement, I think an outright open bidding just to the sheer highest bidder is probably unlikely. But I think you could see in the next 10, 15, 20 years a situation where some kinds of payment and maybe even some kind of monetary competition is ultimately allowed.
Where one player makes more than another.
It very easily could happen.
Well, one could say, well, we're doing this in pro basketball, we're doing this in pro football and baseball, and I'll let it stop there. But and how is that supportable? Because here we still have teams that are competitors with each other, agreeing on how much the salary cap is going to be, or agreeing on other things that affect compensation.
They agree on who's available for the draft.
That's right.
I mean,
and there is an overriding reason that that's okay, which does not exist in the college. Can you expand on the collective bargaining agreement?
So collective bargaining is simply allowed in pro sports because, and again, it goes back to the courts are really just saying, hey, we can't apply the antitrust laws the same way they would to private businesses, because without this structure, you can't have a sports league. And if you don't have a league, the competition isn't going to exist in the way we know it. In other words, if it's just a pure open market subject to the same regulations, you're not going to have, I think, what fans view as key to sports as we know it, which is, divisions and conferences and playoffs and championships. I mean, none of those things can exist without some form of agreement. I think in the context of the NCAA, I think that the Supreme Court has recognized for some time, and the Ninth Circuit continued to affirm in the O'Bannon case, that there is a difference, and that being tied to a university and not being a complete free agent type of system as exists in pro sports is permissible, and I think that's going to be sustained. I think the question is whether allowing an absolute bar on compensation of any kind is going to continue.
Yeah.
And if the courts are going to apply the antitrust laws, even under the more relaxed analysis of this rule of reason, as they call it, I think you're going to see some erosion of that outright ban over time. And I think the question is going to be how incremental it's going to be and what kinds of things are going to be allowed. And I think it's something that's going to play out in the courts. I think the Ninth Circuit's decision really opens the door for a lot of that kind of litigation.
Mm-hmm. Yeah, it may be a situation worth mentioning that college athletes in one part of the country, I've actually forgotten where now, tried to organize and say they could be a union.
It's in Northwestern.
Northwestern University, yeah. And if they get to be a union, then they can enter into a collective bargaining agreement, which is exempt from the antitrust laws. And now that unionization did not work out. As I recall, it was...
I believe the Labor Relations Board actually initially allowed it. I think a court or maybe an administrative body above said, no, we're not going to allow that.
Yeah.
But I think that's the kind of incremental change and attempts we're going to see. And if the courts are going to start applying the existing labor and economic laws, even in a relaxed state, I think change is certain. And the question is just going to be how much the courts are going to allow. And I think it's largely going to be driven by how the courts want to apply it. Again, they're not, with the antitrust laws, they're already admittedly not applying them the way they would apply anywhere else. And so it'll be interesting to see how that body of law evolves.
Have the university presidents or the athletic directors of the country stepped in and offered opinions or help? Are they being represented? What's their take on all this?
So that's an interesting question. In the O'Bannon case, there were 2 or 3 athletic directors that testified at the trial in the district court proceedings, and they were largely supportive of the NCAA. And I think that's one of the things the players were saying is, look, these athletic directors make several $1 million a year. We're the real product, and we make nothing. That's a key part of their argument. Mm-hmm. But by and large, the athletic directors are supportive of the NCAA because they're really a part of the NCAA. It's simply an association of the universities that compete.
Changing the subject from the O'Bannon case to a recently announced decision by appellate court in Oklahoma that the Joe Mixon tape is now public record. By declaring it to be a public record, presumably that means that a Freedom of Information Act request can get it for someone who asks for it. Well, how do you see that? And first of all, if that happens, what's likely to be the effect on Joe Mixon's career, rightly or wrongly? I'm not taking a position about it, but also I'd like your view about whether or not that sort of record is a public record.
Well, so for Mr. Mixon, he was obviously charged with a form of assault based upon an incident that happened a couple years ago. I think in these, and the accuser in that case was a female student. And I think, as we've probably seen from the Ray Rice case, if a picture can be worth 1,000 words, a video may be worth 1,000,000 or maybe more than that. And the Court of Civil Appeals recent decision, and that actually was an Open Records Act decision, a media association brought a claim under the Oklahoma Open Records Act, says we want the video. And the Court of Civil Appeals did find that it was subject to the Open Record Act. They may not have actually yet ordered it to be produced. That's still going to be, I think, subject to some further litigation in the lower court, to which that's been remanded. But if that's a public record, I think it's, which the court said it was subject to the Open Records Act under the facts of that case, then I think it's likely to be made public, and certainly that won't be good for Mr. Mixon if that footage of him striking a female student is made public.
Ryan Ray, our guest today on The Verdict. Kent and I'll have a final word when we get back. Hey, thanks for coming.
Absolutely.
There are now 11 million of us who live here and work here. I was 15 when I came here 6 years ago. I raised my family here. I drive my truck to my job every day. The only difference between now and 6 years ago, I do it legally. I wanted to. Because this is my home.
All children deserve a life of hope and love, but sometimes they experience a life of pain, neglect, and abuse.
When that happens, each child deserves all the quality assistance and representation that can be offered in our legal system. For more information, call 23-CHILD.
Oklahoma Lawyers for Children, helping to bring hope and love back to the lives of abused children.
You will always be mom and dad to me.
I really think people are so unaware of the number of kids waiting just in Oklahoma. And I think if more people knew that those children were out there waiting, I think that just by the way we live our lives and the people we talk to, that maybe we can help encourage adoption from Oklahoma.
You will always be mom and dad to me.
The Journal-Record is pleased to be a sponsor of The Verdict. The Journal-Record, since 1903, the best source of Oklahoma business news and legal information. And for almost 30 years, Oklahoma political, government, and business leaders have turned to the McCarville Report for accurate, reliable, inside information. Visit the McCarville Report online.
Welcome back to the set of The Verdict. Our guest was Ryan Ray, and we discussed all sorts of things that could ultimately change college athletics as we've known them.
Yes, and Ryan is an awfully good guest to have anytime, but particularly on a topic that on its face may appear a little complicated. He's able to straighten those things out and make very clear explanations. We appreciate him driving down from Tulsa.
We give website information. Our guest can be reached at nwcjlaw.com. That's nwcjlaw.com. And we have a website, theverdict.tv. Log on and tell us about a guest you'd like to see on a future show. That's going to do it for this week. For Kent Myers, I'm Mick Cornett. Thank you for joining us on The Verdict. We'll be back next week.